program. So may we go to the next slide, please? I don't think I can control the slides, right? Okay, thank you. So how to develop a mock trial case. That's what I'll be discussing this morning. Before a case is actually a case, it's just a dispute. It's a disagreement between two people or more than two people, or it's an offense. Next slide, please. Can I control the slides, Ashley? There we go. Okay, so the dispute is more of a civil disagreement, and the offense is more of a criminal matter. I put together an example. So Mary lends Bob $20 to be returned on January 1st. Bob doesn't pay Mary back on January 1st. Mary asks Bob for her money back, and Bob refuses. So there are two different ways that Mary can seek a remedy. She can either ask a civil court of law to help her get her money back. She can go and she can file a civil complaint. It would basically be a breach of contract action seeking money damages from Bob. If she believes that, the civil complaint would be filed in, of course, the civil court of the Superior Court of New Jersey, and Bob would be seeking money damages and only money damages. That's sometimes where students get confused between civil complaints and criminal complaints. In the civil arena, they're just seeking money damages. They're not seeking to punish anyone. If Mary thinks that Bob took $20 from her without permission, he went into her purse, he took the money from her, he swindled her, that case would be more of a criminal matter. In that case, she could go to her local police department, she could file a complaint alleging that Bob had criminal intent to take her money. He did something he wasn't supposed to, and he violated a statute, a New Jersey criminal statute. In that case, Mary wouldn't be bringing the case as a plaintiff. The state of New Jersey would be bringing the case through the local police and then ultimately through the prosecutor's office. So Bob would be prosecuted for taking money, for wrongfully taking money from Mary. So the difference between a civil complaint and a criminal complaint, students always get confused. A civil case demands money damages, and a criminal complaint is going to seek punishment for a wrongful act. A couple other distinguishing characteristics of civil complaints versus criminal complaints. A civil case is brought by the plaintiff. The plaintiff is the person who has suffered some sort of injury. It could be a physical injury. It could be a financial injury. It's some sort of loss. So in that case, the person bringing the case is called the plaintiff. If it's a criminal case, an individual can go to the police, but ultimately that complaint is being picked up by the prosecutor and taken by the prosecutor. The person who's been hurt in that instance is not considered the plaintiff. They're considered a victim of a crime. And then the prosecutor takes that case and the prosecutor prosecutes the case. A civil case requires proof by a preponderance of the evidence, which is only more likely than not. It's essentially 51% or more. More than 50% is preponderance of the evidence. A criminal case requires proof beyond a reasonable doubt, which is almost certainty. It's not absolute certainty, but it's almost certainty. In a civil case, and this is important because students always confuse this, in a civil case, the defendant would be found liable or not be found liable for money damages. In a criminal case, the defendant is either guilty or not guilty. And then if he is guilty or she is guilty, the punishment would be imposed by a judge. The sentencing would be imposed by a judge. In both cases, the guy on the other side of the V is still considered the defendant. It's just one civil defendant and one is a criminal defendant. So when you present your case, I like to think of the case as sort of everything in between two parentheses. So you have the proponent of the case, whether it's the plaintiff in a civil matter or the prosecutor in a criminal matter, they're going first when you present the case, and they're going last when you present the case. And everything in between the parentheses is the evidence, whether it's testimonial evidence that's being offered by a witness, whether it's documentary evidence, which would be, in the Bob and Mary case, it would be maybe a copy of the contract, maybe a copy of the check. That's documentary evidence. So all of that stuff in between the parentheses is the actual evidence that the judge has said, this is admissible, this is what the jury can consider. So when you present your case, the first thing you do is an opening statement. An opening statement is not argumentative. It's basically the summary of the case, the roadmap of the case. So an opening statement will be concise. It will be a recitation of what the jury is expected to hear throughout the case. The opening statement can indicate which witnesses will be presented and what that party plans to show through that witness. So for instance, they might say, today you'll hear from Mary. Mary is going to tell you how she knows Bob and what their agreement was, et cetera, et cetera. You will have, in this case, 2 witnesses for the plaintiff, 2 witnesses for the defense. So you can state everything that you anticipate the jury is going to hear. After the plaintiff or the prosecution in a criminal case, after that party puts on its opening statement, the defense will go and put on its statement. Again, even though the defense is defending the case, the opening statement is not intended to be argumentative. It's just intended to give the jury an idea of what it is they're going to hear. Following opening statements, the person or the party who's bringing the case will call its first witness. That person or party will ask that witness, its own witness, so the plaintiff's first witness, the prosecution's first witness, that party will ask open-ended questions. Mary, how do you know Bob? What happened between you and Bob? Those kinds of questions. When you're on direct examination and it's your witness, you want your witness to tell the case, to tell the story, to tell the dispute, not the attorney. It's the witness who should be telling the story. Also, with regard to witnesses, if you have a document that you want to get into evidence, that your students wanted to get into evidence, they have to authenticate that document through this witness. So that direct examination witness may be presented with a copy of the check. And you can ask that witness, what is this? And Mary could say, it's a copy of the check that I gave to Bob. Without authenticating those documents, they won't come into evidence. Following direct examination by the plaintiff or the prosecution, the defendant will have an opportunity to cross-examine. And in that case, the defense is going to ask closed questions, leading questions, questions intended to sort of poke holes in the testimony or to tell the defense's story and to establish inconsistencies that would tend to damage the facts or credibility presented by the direct examination. So in these cases, you'll have 2 witnesses for the plaintiff. It'll go direct cross-examination, direct cross-examination. And then after those 2 witnesses are presented, the state or the plaintiff will rest. And essentially the case will be flip-flopped. So the defense will have an opportunity to put on its witnesses and its case. So you have to remember, even though the defense is defending the case, it's their case. So they will put on the first direct examination on the defense's case. And then the prosecution will come in and cross-examine those witnesses. I'm probably making it sound more complicated than it is, but what you have to remember is just follow that process on the plaintiff or the prosecution's case, and then it is absolutely flip-flopped on the defense's case. Both parties get the same opportunity to do direct and the same opportunity to do cross-examination. When the defense has rested, whether it's a criminal case or a civil case, the defense will present its closing argument first. Because remember, there's parentheses. The defense goes second in the opening statement. The defense goes first in the closing argument. And the difference between a opening statement, which just presents the facts in a very systematic way, and a closing argument is that the closing argument will summarize everything that the plaintiff and the defense has shown in evidence. And they have an opportunity to sort of sway the jury and to argue what's relevant, what's not relevant, what's credible, what's not credible, what should be considered more heavily than something else. So the closing argument is the last opportunity to persuade the jury as to everything that's been presented to them throughout the course of the trial. The defendant will go first in its closing argument, and then the plaintiff or prosecution will summarize and follow up. In an actual case, the reason for that is because the plaintiff or the prosecution can listen to the defense's argument and tweak its argument so as to have the last word and the last opportunity to persuade the jury. So that's a very quick overview of how to present a case. Any questions? I'm here.
You can put your questions in the chat. You can put them in Q&A. You can raise your hand and actually ask the question. We're going to give about a couple minutes if anybody wants to ask questions to Ms. Stewart.
Okay, and while we're waiting to see if anyone has any questions, I just wanted to mention that all of this information that Ms. Stewart has given us is by way of background as to the elements of a mock trial. This is for the presentation phase of a trial. It's not how you're going to frame your case. We're going to be talking about that with our teachers next. So I just wanted to clarify, this is background information on the elements of a mock trial. Okay, do we all Ashley, do we have questions in the chat?
Just about having the presentations, and yes, we're going to get a copy of all the presentations. It's going to be listed on our website, and that should be done probably by the end of today, if not tomorrow.
Okay, I probably shoot for that tomorrow.
Yeah.
It would be on the lawfare and law adventure pages of our website, which is njsbf.org.
Okay, thank you so much for hearing my presentation, and I will stick around at the very end. If anyone has questions, I will be here. Thank you.
Okay, next we're going to hear from teachers who have won our lawfare and law adventure competitions respectively. They're going to tell you how they worked with their students to prepare mock trial cases for competition. Lawfare, again, just to recap, is for grades 3 to 6, and Law Adventure is for grades 7 and 8. In these competitions, students and their teachers write original mock trial cases according to rules that we provide in our rule books, which you can download from our website. Please see those rule booklets for details if you haven't had a chance to look at them at this point. Our first teacher speaker is Diane Jablanowski, and she is newly retired. She's been teaching gifted students for the past 20 years, 14 of those at Swedesboro-Woolwich School District, and the last 6 at the Washington Township Public Schools. She started her lawfare experience in 2007. Ms. Jablanowski.
Thank you. Yeah, I did this with basically my 5th grade students, and it was part of our curriculum. I was the gifted and talented teacher, so we did do a unit on mock trial. At the end of my presentation, I do list teaching standards, so that I know there was someone that said you wanted to pitch this to your school district. You can do this as part of social studies or language arts. Or your, if you have a tag program. So I'm going to go through the process that I followed when I did this with my students. And like I said, we did this in 5th grade. I thought what was most important was to hook them. They don't know what a mock trial is. They may not know, what they're trying to accomplish. So I hooked them and sparked some interest by showing them this short mock trial. The video is on YouTube. It's called The People versus Joe Jones, Case of the Stolen Candy Bar. And we did list the link on the page here in the PowerPoint if you decided to watch that. But the students got to see what a mock trial was, or what a trial was. At the end, we discussed what they heard, and I asked them to arrive at a verdict. And then we talked about why did they choose that verdict? What did they hear that swayed them, that made them make that decision? So after that, we went into exploring people in the courtroom just to get some vocabulary. You know, what is the plaintiff? Who is the defendant? The different attorneys, the different type of witnesses. You don't really do a bailiff unless you're going to role play this big time in your school. We then discussed criminal versus civil, and Ms. Stewart did a great job explaining that. It's important for them to know the difference and to use the right vocabulary. And also when they write their cases, they're going to need to know, are they writing a civil case or are they writing a criminal case? Because the way they write it will make a difference. We do go into the State Bar Foundation's website. They have booklets there that are past winning cases, and I would pull some of those and we would read them and arrive at a verdict. And again, discuss, why did they arrive at that? What was in the case that made them choose that? So that when they go to write their own, they can keep these things in mind of what was important to the jury, the people that were listening. I like to use the case of the missing puppy. That is in the New Jersey State Bar Foundation website, the K-2 resource. It's a very simple case, but it is complicated to come up with a verdict. It's a very balanced case. It's very, you know, could go this way, could go that way, but. So that's a good one for them to try to do. I have each of my students write a 2-paragraph scenario, and they each have to write it individually. And we talk about balance. We want to make sure that it doesn't have an obvious outcome or it's not a slam dunk, you know, for either side. And they submit them to me. And then what I do is I keep them anonymous and distribute them to the class, and we read them. And then we work on narrowing it down to one. I talk to them about fact versus opinion. That's very important when they're writing the case. They have to write the facts and not opinions. So we narrow everything down to one, and then we decide to work together as a class on that one case. We decide what law was broken. Is this civil? Is it criminal? Who's the defendant? Who's the plaintiff? And we make sure we follow the rules. There's a very clear State Bar Foundation rules that you need to follow, and we make sure we follow the rules. We go into breakout groups, and they separate between prosecution or the plaintiff and the defense, and they determine who their witnesses will be, and they write witness statements. There's 2 witnesses per side. Because we did this last year virtually, used Doodle, doodle.com. It's really sort of a meeting scheduling type of website. But what I did was put the parts in there and then put the student's name, and they could go in and choose what they wanted to work on and who they wanted to be their partner. And this way, it wasn't like you were having everybody do the same part, and they could see what was still available, what was not, and that worked out really good. Together as a class, we read and discuss the case. We finalize the title for the case and all the character names. We make sure we have the issue, the sub-issue, the concepts, the law. We have everything that's listed in the contest booklet. My students always like to make funny character names, something to do with the case. And if you read the past winning cases on the website, you can see what I'm talking about, that some of the names are, you know, kind of cute and kind of funny, and they enjoy doing that. We have to make sure that the case is balanced. It has to be balanced. It has to be, well, it could go this way, but it could go that way. You just don't want a slam dunk for either side. And then before we submit, we have to submit in January. So before we submit, we just review the case according to those rules and the booklet. It is so important. We make sure we have a name of the case. We need to have a so-and-so versus so-and-so, and then you can still have a catchy name. So, you know, People versus Joe Jones, and then case of the stolen candy bar or whatever it is. But you need to have that someone versus someone in there. And then make sure you have each section. There's a section on the facts, and again, facts, not opinions. What is the issue? You need to list your witnesses. You need your witness statements. There's a section called instructions, meaning to inform the jury of what the prosecution or the plaintiff must prove. Are there any sub-issues? You know, if I'm watching your dog and I tied him to a tree, well, was the rope you gave me good rope? Was it not good rope? Was it my fault? Did you give me a broken cell phone when I was babysitting? So there might be some sub-issues. And then your concepts, it's either going to be preponderance of evidence or beyond a reasonable doubt. And Ms. Stewart had gone through that on civil versus criminal. And then what is the law? And it could be an actual law, or it could be a law made up by the class. It's going to depend on, you know, your topic. And most important is proofread. Spell check doesn't always work. You might have something spelled right, but it's not the right word. And I'm saying the word right for a reason. You know, the spell check may see W-R-I-T-E and not pick that up when you really wanted to write R-I-G-H-T. So it's really important to actually read it and proofread. So at that point, we submit our case, but we don't end it there. We write a script and we present the case. And it doesn't matter, you know, if we still write the case, whether we still write the script, whether we win the contest or we don't win the contest, we still write the script. I think that's an important part of this. And we talk about the parts of the trial and the flow of the trial. And as Ms. Stewart, you know, discussed, there's opening statements, direct examinations, cross-examinations, and closing statements. And we discuss how to pose a question to witnesses. And we go over what is leading questions. And there's a great video called Payne versus Davis. It's on YouTube. And again, we listed the link for you. Those attorneys in this video are very good at asking these questions. And you can have your students listen to these questions, talk about what did they hear, why did they ask questions that way, which question do you think made a decision, that helped you make your decision. We use the case to guide our trial questions. So we would use our witness statements in order to ask the direct and cross-examination questions. The students select what role they want to play in this. Again, I use Doodle. You can break up as many parts as you want. You can have someone do opening statement for the prosecution, someone else do opening statement for the defense. You can break up the direct and cross examinations if you want. I had 10 students last year, and each one of them played a role in the script in the trial. So we were able to break the parts up so everybody had a part to play. We actually write the dialogue, the questions and the answers. And when we put this on, they can actually follow the case and they can read from the script. I don't make them memorize it. We try to keep it to 15 minutes because if we do win the contest and we do participate in the trial for the State Bar Foundation, you have to do it for about 15 minutes. So we just write it for 15 minutes anyway. And you can present this case, present the trial to either a sister school or another class or the class you had last year or someone else. But you want somebody to hear it and ask them what their verdict would be and find out why did they choose that? What in the case carried the weight that helped them make their decision? And you might want to then go back and tweak a couple things. It gives you the opportunity to do that. I always felt it was okay for my students to read from an index card or from the actual script. Some of them were very into it. Some of them had accents. Some of them got dressed up. They were very, very into it. You know, writing the trial is you know, not an easy thing, but I think performing the trial at the end was a bonus. They really enjoyed that. All right, next slide. I don't know if I can control that. So here are the learning standards. There's reading standards, writing standards, civic standards, performance standards. If you decide to go ahead and do this as part of your curriculum, it covers a lot. It covers a lot. And next slide. And here are some resources that I've used. Of course, I use the New Jersey State Bar Foundation mock trial website. The contest rules are there. The past winning cases are there that we read. The case of the missing puppy is there. There's a New Jersey courts website that gives you examples. When my students go to write opening statements, closing statements, I give them samples of what an actual closing statement or opening statement looks like. There's a certain way it's delivered. There's a certain language that's used. There's a certain tone. And I like to have for them to have some samples of what one is before they write their own. And then there is a Teaching Civics website that has some little mini mock trials that we can use. Okay, so that's it. I have to say that the students really do like this unit. They really get into it. Writing it in the beginning is a little tough. It's tough to come up with something, but they really get into it and they really enjoy it. And it is something that they remember. Thank you.
Do we have any questions for Ms. Jablanowski at this point? And you can put them in the chat or you can raise your hand.
All right, Ashley, are you running this or?
Okay, do we have any questions,
I
Ashley?
think Tara has her hand up.
Okay, could you please unmute and ask your question?
I was just curious if you had any suggestions for coming up with a topic for the students to create a trial about. I know that there is, a section of law that each contest will go around, but as far as you said, it's a little difficult to get them writing. How do you bring about ideas and topics to the students to create the trial?
For grades 3 to 6, there is no defined topic. I think the 7th and 8th grade, they get a topic that they have to write a case on, but for 3 to 6, they don't. And by listening to that stolen candy bar and reading some of the past cases before they actually write their case, I think it kind of gives them an idea of what we want to do. Something was stolen, something was broken, someone broke into something, someone lost something, I think it gives them some ideas. And sometimes if they hear what someone else is saying or we read a case, then it's like, oh, I have an idea, and then they'll write another one. So surprisingly, they will come up with some ideas and really good ones. Anybody else?
I don't see any other hands raised.
I don't see, on my screen, I don't see anyone.
No, on my screen, there is no hands raised.
Okay.
I have a quick question.
Yes, let's.
In the publications part of the website, the NJSBF website, in the publications part, did you find any of those resources especially helpful?
If you go down on the mock trial page at there's past winning cases, there's the booklets.
Right.
I used those a lot. Like I would pick one and we would read it and, we would say, okay, well, what do you think? Based on what you read, what do you think? What would your verdict be? Why? What in there made you make that decision? And they don't come together to make that decision. I asked them individually. So you could have 10 students sitting in front of you and 5 could say guilty and 5 could say not guilty. But then we talk about, well, what in the case made you come up with that? But I think those past cases are really, really, really good. A really good resource.
Thank you. And when you learned the people in the courtroom, did you have a good resource for that? Like what is a plaintiff? What is a defendant?
I think you might find that in the civics part of that civics website.
Okay.
But yes, it's easy to find that kind of information.
I'd also like to mention that we can, if you look in our Lawfare and Law Adventure Rules booklet, we can provide you with a complimentary copy of a booklet from the American Bar Association called Putting on Mock Trials. We have a limited amount, but it would be one per teacher, and you can follow the instructions on how to get that. It is free, and we'd be happy to send that to you. And that has simple explanations of plaintiff defense, similar to what you've seen here, but it'll also give you some more information. Having said that, though, I would make the proviso that please don't follow rules in that booklet. Please follow the rules in our rules booklet. Putting on mock trials is meant to be a background resource if you would like to have it. I'd also like to note that the case of the missing puppy, which Ms. Jablanowski has referenced, is available in our mini court teacher's guide for grades K to 2. And you can either download that from our website, or you can order a copy from the publications page of our website, again, which is njsbf.org.
Thank
Okay.
you very much. That's awesome.
Thank you.
Okay, do we have any other questions at this point? Okay, if not, we're going to go on to our next speaker. It's now my pleasure to introduce John Shanigar. Mr. Shanigar retired from Bloomfield Middle School in Bloomfield, where he taught history and later was a gifted and talented teacher for grades 7 and 8. His school named him 2012 Teacher of the Year. He was also the governor's recognition teacher for his district. His class has entered the Law Adventure competition every year since it began and won many times. Mr. Shanigar?
Good morning. As Sheila said, I taught for 37 years, mostly social studies, but for the last maybe 4 years, I was the G&T teacher, which was just phenomenal for this program. I was able to we created a unit on mock trial. So it was actually like a part of our curriculum. When I taught social studies, I used to sneak this in as my current events thing on Fridays, because I think this is such an important program. It hits so many areas. You can make the kids excited. And the first part of it is I get really excited. So I have to tell you, I'm very secure in the classroom, and I'm absolutely terrified doing this. I find the fact that you are all able to teach this way, I feed off the crowd. I feed off eye contact. I run around the room and act like an idiot at times. And just sitting here like this in front of a wall is very strange. I'm so impressed that the teachers in this state have been able to completely change how they teach and do this. So my goal is to see if I can make this part of it at least a little bit easier. This is absolutely my favorite thing that I did every single year. And I think that translated to the kids, which is why they would have a good time with it. So basically we start. The cases can be either civil or criminal, and you've had a discussion about what that means. You see the word proofread there? It is the most important word as far as I am concerned in writing your case. The case should be proofed constantly. I was very lucky. I taught on a team. And when I taught on a team as a social studies teacher, I would ship the cases over to the English teacher to look at. As the G&T teacher, my kids were in different different teams. And what the English teachers did for me was they would make this a class. We would send our case to them. They would put it up on the smartboard, and their class would edit the case. So you're hitting so many levels while you're doing this, but you have to prove. You do this, you get so wrapped up in this, as was mentioned, spell check just isn't going to do it. You have to make sure that what you started out saying as it changed has been consistent all the way through. So the judges have picked two themes, Second Amendment and technological invasion of privacy. You have to address one of those themes in your case. By the time you get to the end of your case, make sure you're ready to turn it in. Look again, okay, this was about the Second Amendment. Is my case really about the Second Amendment? Or is my case really about technological invasion of privacy? Because what happens is over the course of time, your case is going to make a few lefts and a few rights as you're working with the kids. And suddenly you realize we've wandered, we've left the herd, we've wandered over somewhere to the side, and we need to come back in order for it to be focused. Okay, so move on to the next slide. Thank you, Ashley. Okay, so what I do is for prep work is in my history classes. As I said, I did it in current events. As a G&T teacher, it was a unit. So for 2 or 3 weeks, we talked about it. I introduced the themes. I talked about, I defined terms, and we talked about the whole idea of civil crimes and civil cases and criminal cases. Once I've done that and I've defined the terms, then I send them to the Bar Foundation's website, and we actually look at past winning cases. We study them. I'll pick 2 or 3, and the kids read them, and they decide. And then after they've read them, I ask the kids, what did they like about the case? What interested them? Did you think this was an interesting case, and why? Was it the names? Was it the idea? Was this something that appealed to an 8th grader as opposed to something that, you know, really just appeals to adult? No, I read a case years and years ago. It was incredibly well written, but it was about riparian rights. And, you know, that's not that exciting to a kid, even though it was a fantastically written case. Then what didn't they like? Did they not like the names? Did it not meet their needs? Did they think it was predictable? Did they think it was slanted too much one way? And then I asked them, how would you have ruled and why? Describe to me, if you were on the jury, would you have voted for one side or the other? And then finally, why do you think the judge picked it? What about that case was different than all the other cases that came down in front of the judges? What about that made it stand out? List the elements. All right, once we've done that and we've talked about it, each student has a week to come up with an idea. They have to write out just a real short, this is my idea, this is why I think it's a good idea, and this is how we might develop it. And then I put them all up on the smartboard. We list them all up there. We go through them one by one. I tell the kids, you can't say, I like this one because it was my idea. Can we make a case out of this? Is this going to be interesting to people? If we're bored already, then no one's going to be interested in our case. You got to grab them. So is this an idea that's interesting to people? And then after we've done that, we pick the case. Now, sometimes it's easy. Sometimes one case just shines and you say, this is the one I want to work on. Sometimes they divide. And in the early years, there was this one time where the class was split in half. So my colleague who was also doing this in her class said to me, just do 2. And I went, okay, no problem. Wow, it's a lot of work. It's an incredible amount of work. And the funny thing was, I knew one case was really good and it was going to win. And one case I really just thought was boring and was going nowhere. I don't need to tell you, the case I thought was boring won. The case that I thought was really interesting went absolutely nowhere. So what do I know? You know, it's what the judges were in and what the kids were into. But once we picked our case, then I divide them into groups, okay? And how long this takes depends on the class, and it depends on your individual thing. Are you doing this as a separate unit? Are you doing this with kids after school? Are you doing it on Fridays? You know, how does your school work with you on this? All of that. My whole unit was about 6 weeks, but I had the kids every other day. You know, A and B day kids. Once I break them into groups, it becomes a lot more interesting and a lot more chaotic. So what I do is I divide the class into 3 groups. The first group is working on the facts. So they're sitting over there, they're typing up the facts of the case based on the discussion that we had in the room. The next group is doing either the plaintiff/prosecution testimonies. They're either picking our witnesses or we pick the witnesses. And then the third group is doing the defense. At the end of each class, we come back together and we say, okay, let's look at what you guys said, let's look at what you said, and let's look at what you said. They can also work on them at home, but you can only make changes to your group. So let's say you're the defense statements. People can give you suggestions and ideas, but only the defense group can make actual changes to the document. And then we work on that constantly. It sounds chaotic, and that's because it is. They're yelling things across the room at each other. They get mad at each other if they think somebody stole their idea, but we're working all the time. And eventually you're going to find that it comes together and you have the basic outline of a case. So then we polish it up. Then it goes up onto the smartboard, and as a class, we edit it. Now, what we're editing for is, does it flow? Do the witness statements agree with the facts? They have to agree with the facts. You can't do Agatha Christie and pull a witness out from under your hat over on the side. It has to be, everything has to be linked together. Then we ship it off to the English teachers, and kids who aren't even in our groups are sitting in their GNT, in their English class going, well, that's interesting, or no, look at that, you've used that word 6 times. Whatever you've done, we need to fix that. Okay, once that's done, then we go and we take the case, and we then look for the required elements, which I think is the next slide. Okay, so you want to make sure that you hit all of the required elements. So the facts has to be balanced. This is what happened. John walked into the store. The fire alarm went off. The police arrived. John got arrested. Those are the facts. Everybody agrees that's what happened. You can't, and it has to, when I read a case as a judge, when I look at the facts, I don't want to read the facts and say, well, he did it. Because that's like, it's like reading a book where on page 2, you know who committed the crime. And therefore you're no longer interested in what's going to come for the rest of it. Then you go to the issue. Why are we here? What was the point of this case? There has to be a reason we're here. And that reason has to agree with one of those two themes. Okay. And then the witnesses. Make sure you only have 2 for each side. 2 for the plaintiff/prosecution and 2 for the defense. Don't add any extra ones. And you're making sure as you go through that the witness statements agree with the facts. Okay, now the witness statements, this is where it starts to be fun, because you can agree that John walked into the store. You can agree that the fire alarm went off, and you can agree that the police arrested John. But what else was going on in the background at the time that happened? So the witness statements for the plaintiff/prosecution are going to take those basic facts, and they're going to introduce all of this evidence that proves that John did it. John did whatever it is he's been accused of. The defense is going to bring in witnesses that are going to say, no, well, yeah, he walked into the store, but the reason the fire alarm went off wasn't because he pulled it. The fire alarm went off because somebody else lit a cigarette while they were standing underneath the sensor. And so you haven't disagreed with the facts, but you have tilted them to your side. All right, and the instructions, what must be proved to the jury? The plaintiff must prove by a preponderance of the evidence that. The prosecution must prove by reasonable doubt that. And then the sub-issues. Any additional aspects of the case that might make it interesting. Was there a problem with the fire alarm in that store? Had it happened before? Had John been a frequent customer of the store and was disliked by the manager? Those are the kinds of things that are interesting along the way. Concepts, in the educational terms that are involved, preponderance of the evidence, beyond a reasonable doubt, burden of proof, all of those things. And then my favorite part, which is the law, because you can do one of 2 things. You can either take law that applies specifically to your case, make sure that law is directly addressing what it is that you wrote, or you can make up your own law. And you throw in some colons and some letters and some slashes, but the law has to be reasonable. You can't make it legal to kill people. You can't violate the Constitution. But if there is no law that specifically addresses your case, or for example, if you're doing a school, if you're doing something that happened in a school, you can use the school rules. You can use the Board of Education policies as part of that, or make your own up. Just make sure, and my kids probably made up more laws than they actually put in, but they always agree with basic law. Okay, and this sounds like a lot of work, and I just made it sound really simple, and it's not. It's a lot of work, but it is so much fun. The creativity that these kids have that you don't realize, and the kids who rise to the top while you're doing this, who never spoke, never did anything. I had a student that she never spoke, literally never spoke in the class. And we had one, and I was picking the kids to present. And I picked this girl, and they were so mad at me. They're like, she's going to be terrible. She doesn't talk, she doesn't do anything. She was brilliant. But I had seen things in her. She came back to talk to me later and told me how important it was to her. Others have come back. My wife's a music teacher. She was teaching someplace, and they were doing a concert. Somebody came up and said, "Are you Mr. Shanigar's wife?" And she was someone in one of my classes who had come out of herself because of this. The kids come back, they talk about it all the time. You have to make it, I believe you have to make it fun. And that's not always easy. The first year we won, I had 33 kids in the class. Trying to keep 33 kids actively engaged for 50 minutes is insane, but you can do it. It's just a lot more work. But if you're making it fun and they look at some of those old cases and they watch videos of cases that have won and they're like, I could do that. That changes everything. So I'm going to go back again to proofread, then proofread again. Follow the rules, make sure you follow all the rules in there. My classic story, we wrote what I consider to be the best case my kids submitted in the 20 plus years that we entered the competition. It was brilliant. It was absolutely brilliant. I sat back waiting to hear we had won first prize. I was positive, nothing. And I was shocked. So at the next judges meeting, I'm sitting there and they're talking about last year's case. And they said, we have to stress how important it is to follow the rules, because remember we said that the person couldn't be arrested. They had to be detained. I missed that little sentence that said, detained, not arrested. We arrested the guy. And I was disqualified, as I should have been, as my kids should have been. So make sure you follow the rules and proofread and have fun. And if you do those things, you're going to love it. So, any questions?
Okay, do we have any questions in the chat?
No, we do not.
Okay, and I just wanted to re-emphasize what John said about following the rules. It's really important to read the rules booklets before you start. Please do that. If you have any questions after you've read the rules booklet, you can feel free to email me. My email will be on the last slide when we're done with this program this morning. But we do encourage everyone to please read those rules booklet, and feel free to contact me if there's anything in that you don't understand. And I know we'll be talking a little bit more about this later in terms of judging. But sometimes, John, we get laws that don't match what the content of your case was about. So basically, if your case is about apples, please don't use a law about oranges. Make sure the law links up to your case, because that's what it's all about. And again, when you're submitting your case, we don't want a transcript. We want you to follow the sample in the rules booklet. Again, be sure you understand whether the case is civil or criminal, and the burden of proof attributable to each one. For civil, it would be by a preponderance of the evidence, and for criminal, it's beyond a reasonable doubt. And again, lawfare cases can deal with any age-appropriate topic, and the law adventure cases for grades 7 and 8 are limited to the topics that we provide each year. And I just wanted to mention in relation to that, sometimes we get law adventure cases that don't relate to the topics we've chosen for this year. So it's important to stick to those, because if it's not about this year's topic, the case will not be considered.
We have a hand raised, Sheila. Miss Heather Johnson Marvel, I'm going to ask you to unmute to ask your question.
Thanks so much. So with my kids, I got started a little early because we only meet once a week, and they're having trouble narrowing down. I was trying to use the gentleman who just presented. I saw his presentation last year, and I was trying to use as a model to really let this be student-led, but they're being so darn polite with each other, they cannot narrow down the topics very much. And we're wondering how you get them to finally arrive at a topic. Thank you.
Okay, John, do you want to address that?
Sure. When that's happened, it happened my last year teaching. And what I said to the kids was, okay, I'm splitting the class in half. these are the two topics that seem to have the most interest. I want you to write me a mini version of a mock trial, both groups. And then I want you to present that to the other side. And then I want you to vote. And you really have to vote based on, is this going to develop smoothly? Is it going to be something that we can submit? And generally that has worked. Once they actually put it on the paper, they're like, oh no, this is really hard because I don't know what to do for a witness or whatever. So if you can get them to narrow it down to say 2 or 3, then just divvy them up, give them like tonight. I want you to work on it tomorrow in class. You're going to write your case the next day, and you can obviously shorten this however you need to. We're going to vote, and that's the case we're going to use, whatever the majority decides. And the rest of us have to agree that we're going to buy in, even if it wasn't the one that we picked. Hope that helps.
Thanks, that's great, thank you.
Okay, if we have no further questions for this segment, we're going to move on to the final portion of our program this morning. Our next speaker is Carol Moore, who is chair of the Law Adventure Committee, and she's going to address frequently asked questions. Ms. Moore?
Good morning, and thank you for joining the webinar. Before I get to my discussion regarding how entries are judged, on behalf of the Law Adventure Committee, I'd just like to express our gratitude to the teachers and students who submitted entries last year, despite all the restraints of hybrid and distance learning. Kudos to those teachers who continued their commitment to affording their students such a rewarding and enriching experience. Okay, let me begin by reviewing how we judge the cases. As you heard before, cases are submitted, and this year, cases for Lawfare and Law Adventure need to be in by January 31st, 2022, and you can submit them electronically. So they come into the foundation, and they're divided, all identifying information is removed from them. And they're divided into 10 to 12 cases, in our case for 7th grade and 8th grade, and they're sent to the judges who read through all those cases and decide on perhaps 3 that deserve to have some further consideration. Then those 3 from all the judges go back, and all those cases are again submitted to the judges who read them again very carefully, because this is the pool from which, cases, entries that are going to get some kind of honorable mention or 1st or 2nd place status will be selected. We then meet last year via Zoom or in person, and we discuss all the cases, and then we rank them. And we make that determination of 1st place, 2nd place, and honorable mention. And if we are in person, those cases are then have an opportunity to be presented at the Bar Foundation. And there are students who come who act as the jury. And so that becomes quite an exciting experience to actually see those cases performed. Now, at the end of the year, we always get a lot of questions as to why wasn't I've been doing this for a number of years and our cases are never selected, or can I write it like a story? Is there some way I can find what a winning case looks like? And I think the other speakers have addressed that there's a lot of information on the Bar Foundation website that you can access to find good examples. But let me give you some suggestions, and I hope you'll take them to heart and maybe make this list and put it up for you to look at as you go through, writing your case with your children, so that you will keep this in the forefront of what's really, really important today. There are 5 basic areas that I think are most important that we look at when we judge the cases. Is the format followed? You've heard that multiple times today. Format is most important. Is there balance in the case? What is the length of the case? Is it too short? Is it too long? Is it publication ready? That proofreading that really needs to be done, because you need to realize that at the end of the competition, those cases are taken and uploaded onto the Bar Foundation website, and they need to be really publication ready. And is there an element of creativity in that? All right, I'll just go quickly over, excuse me, some of the format questions so that you'll see some of the things that may disqualify a really well-written case from being followed. Ashley, can we get to that format slide? I don't have access to doing this, so. Okay, here are the 5 things that I hope you'll take note of and look at that as you're doing it. And the next slide, please. Great. Okay. And I think we can go on from that because as we said before, John and Diane explained that beautifully, what's most important. So we'll go through. The first thing is the title. We ask you that you please write a formal title for the case so that if it's a civil case, it would be something like Jones versus John Wallace Middle School. I think if we're on the next slide here, if we can get there. And I'll go on anyway. Okay, great. And you can add an interesting subtitle, something that's underneath it, like putting a lid on living history, something that's creative, and your children have an example. And remember, if it's civil, it's person versus person or entity. If it's criminal, it will be the state versus somebody else, okay? The facts. Now, there's a lot of creativity that goes into writing the fact statements many times. But as we said before, I would instruct my students to write it as if they were writing a newspaper article. The who, the what, the where, the when, everything but the why. So there should be no conclusions drawn, no testimony, just simple facts. But you can write it in a fashion that makes it really interesting. Sometimes when we're reading a lot of cases, and because in law adventure, we're limited to 2 topics for the year, we get multiple cases that address the same kinds of issues. Those that are well written and interesting, especially when the facts are written or in some of the further statements, really set cases apart that may be similar in content. The issues. If the issues that you state don't really address what you're asking the jury to look for, then those cases will be eliminated. Remember, if you're looking for culpability for damages in a civil case, or if you're looking for someone who didn't follow the law in a criminal case, that needs to be stated. What's being investigated and what needs to be decided upon. The witnesses. Remember, only 2 witnesses for the plaintiff or prosecution and 2 witnesses for the defense. In the first part, where it says, asks you to state witnesses, you give the plaintiff or prosecution the witness's name and the relationship to the case. For the defense, you'll do the same thing, naming the witness and their relationship. And the next section that follows are the witness statements. I think most of us have watched television shows where there are a lot of police shows and law shows where you see witnesses being questioned by the police department. And after they question them, they ask the witness, would you please write your statement? And this is the representation from the witness as to what they thought transpired and what their involvement is. It's totally their words and about their actions and their deeds and the circumstances that they saw at the time. The next part, which often is the disqualifier for most cases, is giving the instructions. So many times, and this is really, it pains us because we see beautifully written cases that are interesting and involved and have catches in it and they're creative, and they put the wrong instructions. They'll say, find the plaintiff guilty. Well, a plaintiff is not guilty. A plaintiff would be found liable by a preponderance of evidence. And if it's a criminal case, it must say beyond a reasonable doubt. So please make sure that this section, the instructions, is accurate and relates to the type of case that's being presented. Next slide, please. Can we get, good, the sub-issues. A list of facts and questions that should be considered. Could the witness really see what was happening? Did they have their glasses on? Was the person speaking in a different dialect? Is there credibility of the witnesses? These are all points to be considered. And then the concepts of the case. What is the law that needs to be considered? And that should be really clearly stated. The last section, the law, is a section that so many times students and the teachers leave to the end and don't put a lot of time and effort into it. And what happens is this case is so full and beautiful, and then you get to the law and there's nothing there. And then you're comparing it to another case where they did take the time to make sure that laws, real or imaginary, are presented and they show the relationship to the case. So basically, all the sections of the case need to be written as completely as possible, and don't eliminate this last section of it, the law. It's an important one and can also be the tipping point of whether a case gets recognition or not. Next slide, please. Okay, balance. I think, you know, the other participants today, Diane and John and Kimberly, spoke about how it's really important that the case you presented needs to be well balanced. If it's heard twice, could there be a possibility of different verdicts on it? When you read it, is it readily apparent that one side is so well developed and the other is not? So please work hard and have the students switch sides so that they can make sure that their presentation for the plaintiff or prosecution and the defense are well balanced. The length of the case. Some cases are incredibly long. The facts are written as a novella or, you know, a really excellent short story, but that's not what we're looking for here. And some cases are presented that are really very sparse, and you just wanted more meat in it so that there would be a fullness when they're able to present it. So neither too long nor too short. You know, it's like the porridge. You got to find just what's right. And is your work publication ready? Grammar, syntax, consistency of names. Sometimes, you know, witness names change in it, or facts of placement. The names change, but they don't change it all the way throughout the case. And that, you know, that's a red flag. Cases that have multiple errors in it, especially grammar and syntax and spelling, we're really looking for something that really is publication ready. And John and Diane gave great examples of proofing it, and especially with the use of technology in your classroom, putting it up on the screen and going over it and marking it up is really an important thing. And creativity. Is it interesting? Is there something about it that makes it stand apart? I'm going to give you an example at one time, and I'm speaking actually to a case that we didn't know at the time that one of John's students groups presented to us. And it was a case where a parent was at a game and was accused of making a statement or getting involved in the play of the game and creating distress for one of the players. And she was speaking in another language. And one of the things that came up was, were they speaking the same dialect, and did the words have the same meaning in those two dialects, which was really an incredibly creative twist that was put into that case, which just made it stand apart. And so I applaud you all for coming today and listening to our presentation. And I'm excited to be reading the cases that your groups will be presenting to us. I encourage you to please look at our website, NJSBF.com, and check out all the material that's there. And if you have any questions, please feel free to email Sheila with those questions, sboro njsbf.org and ask her those questions, and hopefully we'll get back to you. So I look forward to reading your cases. I hope they're great. Good luck.
Okay, do we have any questions for Ms. Moore at this point? Okay, any questions in the chat?
No.
Okay, again, I want to thank you all for joining us today. We did do our in-person, last year we were not able to do in-person mock trial presentations at the Law Center because of the COVID-19 pandemic. We don't yet know what the situation will be in May this year. We certainly hope it will be in person. We did do this virtually last year, so we'll monitor the situation and we'll keep everyone apprised on our website as the circumstances change, and hopefully we will be able to do this at the Law Center again in person in May. And as I said, if not, we will do it virtually as we did last year. That worked out really well. So one way or another, we will get there, and we thank you for taking the time to join us this morning. As Carol mentioned, please feel free to email me if you have any questions. I'll be happy to answer them. And again, I'll just end on what we've all been talking about this morning. Please read the Lawfare and Law Adventure Rules booklets before you begin work with your classes. If you have questions, feel free to ask me. We'd be happy to work with you, and look forward to having another great year for Lawfare and Law Adventure. Thank you all so much.
Now I'm going to stop sharing. I'm going to post a survey in the chat that we ask that everyone fills out just for the programming and see how we can make it any better. So I'm posting it now. And again, we'll be emailing a link to the professional developments shortly after this meeting. If not tomorrow, then the first thing next week, that you'll need your information that you signed up with to access.
Right, this will be for a professional development certificate that you would be able to download yourself, but you do need to use the email address that you used to register for this webinar this morning in order to access that certificate.